Welcome to Real Estate Resource. Thanks for stopping by. Don't forget to like, subscribe, and hit that notification bell so you'll know when new videos are available. I really hope you enjoy this one. Okay, good morning again. So on December 16th, CAR is going to release some new forms and some updated forms, right? So they're making some changes to forms that currently existed. So today, I think it might be 2 classes to get through some of these. I'm not sure, how much time I'm going to spend on each form, but I'm going to look at the updated forms, which are the buyer representation and broker compensation agreement has been updated. The PSRA has been updated. The RPA has been updated, and the RLA has been updated. And the SPBB has been removed. So come December 16th, that will not be required. That's the seller payment for buyer's broker. So that's not going to be included. That has, as you'll see soon, has been absorbed into the RPA. And let's see, we got something in the chat here. I have a question. When I counter out compensation, do I do that in a regular SMCO? Yes, when you're countering right now, for the next 2 weeks, obviously, well, forever, you're going to, if a buyer's agent is requesting compensation, or if the buyer is requesting you to give a concession that they will then use to pay the buyer, because that's really technically how this is working. If that's the case and you're going to counter the amount of the concession, right? Say they ask for 2.5% and you're going to reduce it down to 2%, then your counteroffer would read concession to buyer for compensation of buyer's broker to be 2%. And for the next 2 weeks, you're going to add the verbiage updated SPB attached to counter to be signed and returned with this counteroffer. Because you have to update that SPBB, and you can't count on the buyer's agent to do that once you change the compensation. So that needs to be done. After the 16th, you won't need to add that extra verbiage in for the SPBB. It's funny, I just had a phone call from an agent right before we started the class. I was asking the same thing about countering out, countering the compensation. But yes, now as opposed to what happened prior to August 17th, right, when we used to do compensation was a shared compensation from buyer listing broker to buyer's broker, and now that's not the case. We used to say don't reference compensation in the purchase agreement because it has nothing to do with buyer and seller. Now the compensation has everything to do with the buyer and seller. So yes, that's going to be in your counter offers if you need to address that, right? Change the amounts or anything like that. All right, so let's get moving. I'm going to go ahead and share my screen. And I think the first thing we'll start with, we'll start easy. And I'm going to start with hopefully I'm sharing properly. Are you guys seeing the open house visitor non-agency disclosure and sign in? Just give me a little thumbs up, those of you on camera or on the chat. Because last time I know I had made a little mistake with my share, so I got a thumbs up, so everything must be good. All right, so what we're looking at right now is the open house visitor non-agency disclosure and sign-in, and the reason I wanted to bring this up because this is a really quick little change, is they've added to the OHNA that it's not only for open houses, but maybe for private showings of a property where you're not representing, you haven't made an agreement to represent them yet, but you want to open the property, so it puts you in the same position as an open house, and that you want to make sure that there is a non-agency agreement between you and this potential buyer, that you're working for the seller. So you can use this now for individual private showings. Okay, so let's say that you get a sign call and you don't go through the whole process of getting somebody approved or pre-qualified or whatever, but you do want to show the property, you can have them sign this, and that would cover you because you have that non-agency agreement. Now, if after that showing they say we want you to represent them, then you could do the PSRA or the BRBC. Okay. Does that make sense to everybody? So that, like I said, this is a small change. That's why I started with that one. Any questions? So you guys know, just again briefly, the OHNA. This is what you sign just to let the buyers know at your open houses that you are not representing them in any way, and any information that you provide to them is based on your responsibility to represent the seller, and that the information that you're giving is to do your job for the seller. Okay. They have to put their name. If they have an agent, they can put the name of their agent, their email, their phone number. That's it. You keep that. That doesn't have to be signed by anybody. Just has to have their name on it, have their agent's name if they have one. You keep that in your file, just so somebody can't come back and say, hey, they were acting as my representative, and you have this to show otherwise. Okay. All right. So let's move on from the OHNA. And since we referenced the PSRA, I'll start there. So the PSRA, just again a refresher, the PSRA is the Property Showing and Representation Agreement. This is a non-exclusive only representation agreement, meaning that it's for specific properties. Okay? For specific properties. Now, it used to be, prior to the 16th, is only 3 properties were allowed to be put on the PSRA. Now what they've done is they've added this little box here, as you can see, that says see attached list of properties. So you could put more than 3 properties as part of this property showing agreement, right? If you want to show 5, 6, whatever it is. Everything else is basically the same, and you'll see some of these same changes in the BRBC. The broker created. So remember, prior on the BRBC and the PSRA, there was the box that said or attached compensation schedule. Well, since CAR didn't create a compensation schedule, this is saying you're using a broker created compensation schedule. So it's separating CAR from this compensation schedule that was completed, so that if you make a mistake or you don't follow the rules the right way with compensation, it's on you because the broker created it. So that was a change that's added to this, and I'll show it to you also in the BRBC. What was added to this one also was a continuation period that isn't on the current PSRA, meaning that on the properties that are listed on this, either here in this 3 spaces for property addresses or on the attached list, there is a continuation period if after this 30-day PSRA expires, that you would still be entitled to compensation on those properties. Okay. That was the changes to the PSRA. Any questions about those changes or the PSRA in general? Anybody? Nope. All right. Oh, I see a hand there. Jasmine, go for it.
Hi, Kyle. Okay, so yesterday, well, I was going to call you and email you, but that's it. This is a little too late. I have a new listing, but I have to co-list it with another office because it's a divorce. Well, it's not even a divorce. They're not married. Actually, the couple's not married, and so they bought a property together. So now they're selling it, and I was gonna mark there where it says schedule of compensation, but then when I went all the way to the bottom of the signatures, I saw if 2 offices are representing the office, I checked that, and then it gave me another form. So am I okay to go that route versus that part where it says schedule compensation?
That's the only way to do it. So you're required, when there's 2 brokers, that you have to include that additional broker acknowledgement form, and that additional broker acknowledgement breaks down the compensation that's being paid by the seller, which is what you're going to put in the compensation section of the listing agreement. It breaks down how that is going to be split between the 2 different brokers.
No, because the client is actually, my client is the one actually residing on the property and handling all the bills. She's going to give me I'm going to set it up on the MLS. I'm going to do everything. And I'm just going to put that agent as a co-agent, right? But I realized that on the MLS, it only gives me my information, but the co-agent's information will pop up, I guess, on the CRMLS, or it'll pick up his information.
Well, you have to put
Okay.
it in. Yeah, you have to put it as public ID.
Okay. All right. Thank you, Kyle.
You're welcome. All right. Moving on. Let's move that now to the BRBC, which is our main the main form we're going to use for representing a buyer. And just while we're on this, guys, I cannot stress enough that this BRBC needs to be created prior to you showing any properties to the buyer, period. Unless you have now, have come the 16th or, up until then, you have an OHNA that was the non-agency because you did the private showing and then they chose after the fact to work with you. Unless you have that, this BRBC needs to be done prior to the showing of any properties. When you are the listing agent, your file, if your seller is paying any compensation to the buyer, you need to have a copy of this buyer representation agreement in your file. The amount of compensation that you can make as a buyer's agent, and I'm going to keep driving this home, is capped at the amount of money that you put into this BRBC. So if you put 0.5% or 1%, it doesn't matter what the seller is going to give you. That's what you get paid. Okay, so I just need you guys to understand. I see so many files and transactions where the BRBC is either not filled out correctly, or it's not dated properly. The listing side doesn't have a copy of it. This is stuff that we've got. I know we're still, just a couple months into this or 3 months into this, but you guys have got to wrap your head around it, because ultimately, as we get deeper and deeper into this, just like that past lawsuit with compensation, if you don't think lawyers are going to figure out a way to find out how you weren't protecting your client or filling out this or getting them to pay the compensation correctly, they're going to have to come through. They're going to come through with this. Let me see. I got some in the chat. I don't have to sign the buyer's BRBC and counter it and do a new one with my seller's signature. The seller doesn't sign ever the buyer representation agreement. That's just, you need to have a copy of it, because that's what's showing is the proof of the compensation that you're allowed to pay the buyer. And the SPBB is going to be gone in 2 weeks. So for the next 2 weeks, yes, you have to have that. And it has to be signed by the seller. Absolutely, because the seller's agreeing to pay something. So BRBC, remember, it is limited to a 3-month period. That's it. It can't exceed 3 months. And you can modify the time, but the agreement itself can't exceed 3 months. Okay. Now, here are some changes in the current BRBC. And I saw your hand, Jesus. I'll get to you in a moment. In the current BRBC, it was confusing, and I had noticed a few times people were checking boxes that they shouldn't have. There was a box that said SFR excluded with all these other multifamily, residential, industrial, all that stuff, and people were just checking all the boxes, which means now that any single family residence was excluded. Okay. So now what they did is they moved it to a separate section where it's in parentheses, and it says this is for single family residential, including condominiums and manufactured homes, or if we check, we're excluding this from the agreement. So they made it a little bit clearer so people don't check that off. Okay. That's been added. Again, the broker created compensation schedule was updated. Another change that was made was in the cancellation rights. Okay. So currently the way our BRBC works is if it's non-exclusive, I can cancel it immediately. If I give you cancellation instructions, and there's a form I'll show you in a moment for canceling. If I can cancel it right away, here's your cancellation, I'm out. Or if we filled it out with days, it cancels so many days after you get it. With an exclusive cancellation, it right now is 30 days. That's it. You have 30 days. Once it gets to 30 days, now it's canceled. They've added here where you can make it shorter. Hey, if you give me cancellation in 15 days, it's canceled. In 10 days, it's canceled. It just can't be more than 30. So you have a choice on an exclusive. It stays at a 30-day cancellation once you get cancellation instructions, or you can shorten it, but it can't exceed 30 days. Okay. The next change, which I really enjoy is that they changed the verbiage here on that section where it says buyer does not have sufficient funds to pay broker. They added in here, buyer's broker's obligation to represent buyer in a transaction is contingent upon a seller's agreement to pay the amount of compensation. So basically what it's saying is, I, buyer, can't pay your compensation. So any offer that we put out, any transaction we get in is contingent on the seller paying it. And if the seller can't pay it, you don't have to represent me. So I like that change in the verbiage because it really clarified that. So when you have a buyer that really does not have the funds to pay you, you want to make sure you're checking this box. Okay. All right. So now let's get to Jesus. You had your hand up. Go ahead.
Hi, Kyle.
Hi.
I thought I heard you saying that the SPVB is going to be gone in 2 months?
No, in 2 weeks.
In 2 weeks?
Yep.
That's the seller paying
payment
the
to buyer's broker. Yeah. It's going to be gone in 2 weeks. It's going to be rolled into the purchase agreement, and I'll show you guys that in a moment when we get to the purchase agreement. But the SPV will not exist in 2 weeks.
But it will be attached on the contract.
You'll see in a couple minutes. As soon as we get to it. Yep. All right. Okay. So I like that they added this because now it's clear that, first of all, number one, it's okay. Because remember, we were kind of guessing that it was okay with this new compensation structure that we could say, I'm only going to show you properties where a seller is willing to pay compensation. But now we have something affirmative in contract that was done by Sierra that says, hey, look, my representation of you is contingent upon the seller paying compensation, which I think is good. So that clarifies how that works as far as compensation works, because now we know, hey, if it's not either we're not going to write the offer or I'm not representing you, you're on your own. Right, when it comes to a property that they may have interest in where the seller is refusing to pay any kind of compensation. So I like that addition. That's a good addition to this BRBC. I think that makes the conversation with your buyers a little easier, right? Because prior to that, it was still on the fence. Like, does that mean that I can only show properties where the seller's paying? It doesn't say that. Do I have to show them everything? How does it work with the representation? So I think this clarifies, makes it easier for that conversation with your buyers. Okay, any questions on the BRBC? No? All right. So let's look at, since we talked about the cancellation of the buyer representation agreement, here is the form, cancellation of buyer representation. So this is very specific to, this is how I cancel. So parties, the broker, the buyer, the buyer representation agreement, what the date of it was, the notice of cancellation of the representation. By signing the applicable box below, buyer, broker, or both hereby gives notice to the other to cancel the buyer representation and terminate their agency relationship duties and responsibilities with and to each other. Compensation may be specified as specified below. Okay, so unilateral cancellation, that's one or the other. The buyer is one person is canceling, right? The buyer representation agreement for non-exclusive representation, the cancellation is effective immediately upon receipt of this notice or on days after receipt of this notice. Or B, the buyer representation agreement for is exclusive representation and cancellation is effective 30 days or blank days from new notice. Or mutual cancellation, regardless of the type, buyer and broker agree to mutually cancel the buyer representation immediately upon receipt, the last signature of mutual cancellation of the box. Okay, so you have three choices for the cancellation. So basically what they're saying here is your buyer calls you and says, I don't want to work with you anymore. I want to cancel. Okay, now you could obviously try to talk them out of it before you do that. But if they're adamant they want to cancel, you give them this form saying that they want to cancel when the cancellation is effective. You send it to them, you sign it, they sign it, and whether it's non-exclusive or exclusive, it's either canceled now or 30 days from now. That's it. Okay. Now, the scope of the cancellation. This cancellation notice applies to all properties that may be subject to the buyer representation, or this cancellation notice only applies for the following property. So let's say, for example, you had a PSRA that had just one property on it. You could do that cancellation for this. It's only good for 30 days, so it doesn't matter. Like, it's non-exclusive, so it's an immediate cancellation anyway. Or when you do that for the following property, it does say that that agreement remains in effect for all the other properties. So let's say that, for example, I had a buyer representation agreement with Jesus. His brother decided he wanted to sell his house and they were going to do a private party sale, and Jesus wanted to buy his brother's house, but he didn't want me to be involved because they're doing this private party sale. He could come to me and say, hey, I'm going to try to buy my brother's house. I don't know if it's going to work out, but I would like that to be exempt from our representation agreement. I could put that property in there, and then it's still, if he goes to go buy something else, my representation agreement still exists, but he's free to buy that one if that one works out. That could be an example of how you could put a specific property in, okay? If checked, this unit is provided because the seller property identified in paragraph 2C has been declined to pay out. That's also, right? So going back to what we talked about with the BRBC, where it said, hey, I only represent you if the seller agrees to pay and the buyer wants to move on with not being able to pay the compensation like we had checked, then I could do it with that property also, but it would stay in effect with any other property, okay? You can put in here compensation due to us on the cancellation, so if there was any expenses or anything like that, or we owe no compensation, or I'm going to get a referral fee, whatever it is, you can pick those as part of that cancellation, okay? Everybody signs, and you're canceled. Questions about the cancellation of buyer representation? No? All right. So let's do this since we're getting the questions about the RPA and the SPBB. Let's look at the RPA. So a couple of changes, the way they've added a form called the IDA. They've changed it, right, for the increased deposit. Instead of having the details in the RPA of how the increased deposit's going to work, they have a new form for the deposit, so all the terms of that increased deposit will be there, and we'll look at that another time. But we get down here. Additional seller credit terms does not include buyer broker compensation, because right here it says they've now changed it for closing costs, like there's nothing to check off what that credit is for the seller. These are the terms of the credit, additional seller credit terms, that's what we're talking about. Now, look here. Seller's payment for buyer's obligation to compensate buyer's broker. Seller agrees to pay out of the transaction proceeds blank % of the final purchase price and, if applicable, a flat rate, or if checked, a flat rate toward the obligation of buyer to compensate buyer's broker. Buyer firmly represents that at the time of this offer made, buyer has a written agreement with buyer's broker that is valid, covers the property, and provides for compensation for no less than the amount stated above. So now what they've done is they've just gotten rid of the SPB altogether, and everything is right here in the purchase agreement. Jesus, you have your hand up. Go ahead.
Yes, Kyle. You mentioned going back on the cancellations. You mentioned that whether it's exclusive or not, with the new clause, with the new document, now they're able to cancel whether they're exclusive or not immediately. Is that correct?
No. If it's exclusive, it's 30 days maximum.
30 days. Okay, perfect.
If it's not exclusive, it's immediate. If it's a mutual cancellation where you guys are agreeing we just don't work, then you can make it's immediate. Okay.
Even the exclusive. Even the exclusive, yes.
If
there is mutual agreement.
Yes.
Okay. But if the buyer wants to cancel, but the buyer's agent doesn't want to cancel, it cannot be canceled. Is that what you're saying?
No. I'm saying that it is canceled, but it takes 30 days to go into effect. There's no way around canceling. If the buyer wants to cancel, they can cancel. It just depends on if it's exclusive or non-exclusive. If exclusive, it's a maximum of 30 days by default, unless you put something different in there, but it can't exceed 30 days. And if it's non-exclusive, the minute they give you the cancellation, their agreement with you is canceled. That's it.
Okay. Perfect. Thank you.
All right. Okay. So I think this is great that they got rid of the SPBB. I think it was confusing. I don't know why, but it was confusing for agents. They didn't understand why they needed the SPBB. It was confusing for listing agents when they were doing counters that needed to be incorporated. So now it's all in the purchase agreement. So going forward, from the 16th forward, when this comes out, When you're countering the amount of compensation, you're just going to counter it just like that. The seller payment for buyer's obligation to compensate broker amount to be 2%, 1%, whatever it is, that's how you're going to counter it. And that's how it's going to work. That's it. But you still need a copy of the BRBC because it's showing that, hey, the amount you're agreeing to pay me is is equal to or less than the amount that my buyer agreed to pay. Yes, Jasmine.
Kyle, I don't see the box where it says for unrepresented clients.
This is not the listing agreement. This is a purchase agreement.
No, yeah, but remember on the purchase agreement, there was a box where it said additional,
No,
where you said
that's
we
on the
shouldn't be
listing
charging.
agreement. That's on the listing agreement. That's not on the purchase
That's on
agreement.
the listing for
Yeah.
non-represented? Okay,
Yes.
sorry about that. Right.
Yeah. Uh-huh. Okay. One other change, I mean, there's some other little tiny changes that were made, but one other thing, and it's on the listing agreement, it's on a lot of the documents that are being updated, is they changed the entity seller or entity purchaser or entity seller. If there's an entity involved in the transaction, they changed that section. So let me get down to the signatures so I can show you that. Sorry if it's making you dizzy. Here it is right here. So they changed the entity buyer section. They added in some stuff. They talked about, it's more detailed, right? So it's non-individual entity buyers. One or more buyer is a trust, corporation, LLC, probate, estate, partnership, holding a power of attorney or other entity. The full entity name, what that is. If it's a probate, you got to put the case number. Like if you just put the estate of, you put the case number of the probate. If it's a trust, you put the full name of the trust. Contractual identity of buyer. For purposes of this agreement, when the name described below is used, it shall be deemed to be the full entity name. If a trust, the trustees of the trust, or a simplified trust name, John Doe, co-trustee, Jane Doe, co-trustee, or Doe Revocable Family Trust. So what they're saying is any reference to that name, the John Doe Revocable Trust, any reference to that Doe Family Trust is considered okay in this identity of the buyer. But it all has to be stated here in the purchase agreement, in the listing agreement. Okay, if property is sold under the jurisdiction of probate court, the name of the executor or administrator or a simplified probate name, John Doe executor or estate or conservatorship of John Doe, will be acceptable. So in the past it wasn't. I know that sometimes that we were putting the names of the trustees and things like that. It is acceptable now for the transaction if it's a shortened version of that trust name. Okay. The legally authorized signer, this agreement is being signed by a legally authorized signer in a representative capacity and not for him or herself as an individual. The names of the legal authorized signers are, and then you put the names of the people who are signed. Okay. So they added that. You're going to see that on anything where there's an entity as a signature section. You're going to see this new change to how that entity signature section is filled out. Okay. So let's go to the RLA now. And let's look at the RLA. So again, they added the broker created compensation schedule verbiage here, right? So again, CAR distancing themselves from that form that is not an official standard form of CAR. Okay. Here's the additional compensation to seller's broker if buyer is unrepresented, does not apply to dual agency. Remember, this is not you representing the buyer. This is if a buyer shows up, has no representation, does not have the money to pay for representation, the seller is not willing to pay any representation for a buyer's agent, but because you have to do some extra communication with that, on their own buyer, they're going to pay you an additional amount of compensation, a half a point, 1 point, whatever it is you negotiate or that you can make sense that there's a value in there. If broker represents both buyer and seller, buyer side compensation shall be specified in a separate written agreement between broker and buyer. Okay, that's it. There's the additional compensation part that Jasmine was referring to. They added this publication of seller willingness to consider concessions. So now they have a section in there that's saying, hey, the seller is wanting us, is saying, yes, I want this to be publicized. If checked below, seller authorizes broker to market that seller is willing to consider offers asking for concessions, and no amount of the possible concession will be stated in such marketing unless seller notifies broker in writing of the amount. So if it's permitted in the MLS, which ours does not permit, it says you could, if they check this box, you could put that they're willing to pay compensation. If they check this box, it says any other marketing outside the MLS. So now what's happening is that means that your seller has now authorized you to publicize, hey, on your flyers, on your website, on Facebook, wherever you're going to do it, that they're willing to offer compensation. Now, unless they give you something else in writing that says, I want you to tell everybody I'm paying 2%. You can't put the amount, but you can say that they're willing to pay those concessions for the broker compensation. Okay? So, or for any concessions. But I think that is great, but not in the MLS because our MLS doesn't allow it. It says right here, in the MLS listed above, if permitted by that MLS. Our MLS doesn't permit it. So we know we're not going to check this box. But we want to have this box checked for the any other marketing outside the MLS that they're willing to pay concessions. We want to put that out there if that's what you're doing. So now you have an instruction that says, hey, we're willing to pay concessions to the buyer. Yeah, you can't put the amount, just that they are willing to pay concessions. That's it. Okay. All right. And I think that was all I wanted to cover on the listing agreement. There's just some detail about the concessions, right? Concessions are monetary payments that a seller agrees to contribute towards a buyer's expenses and other costs a buyer is responsible for in the transaction. Concessions may include, but are not limited to, costs of escrow, title, lender fees, repairs, inspections, and buyer broker compensation. Concessions specified in MLS must be allowed to be used for any permissible buyer expense or cost and must not specify that concessions are to be used for broker compensation. However, a term in the buyer's broker may specify that the seller agrees to pay all or a portion of the compensation that the buyer owes its broker. Concessions identified in the MLS listing are not promises to pay, but instead indicate to a buyer that the seller is considered. Offers asking for concessions specified in the MLS are not intended to be binding on seller unless included in the accepted purchase agreement. I mean, there is that concession. I think on the MLS, there is a section where you can put concessions, yes or no. That's it. So, I mean, you could still check that box and put it in for the concessions. No, don't reference that in private remarks. There is a drop down that says yes or no for concessions. Just do that as a yes. So someone put, can we put private remarks, call agent regarding seller concessions? No, don't put that in the remarks. It's going to get flagged. They'll take it out right now, but later on it could turn into a violation. So don't put anything about concessions like that written out. There's just a drop down. Okay. It does say that you could state the amount of concessions if they give you the instruction in writing to do it. I would stay away from that in the MLS because that doesn't give you a place to do it. All it lets you do is put yes or no on your flyers, on your website, on your public marketing. That you can do. That's fine if you get written instruction from your seller to do that. Again, and then the changes again about the non-individual individual entity sellers. There's the change that we saw before. Let's see. What is next? Oh, so I'm going to bring up a counter offer right now. So I know in the past, I've had discussions with you guys about the expiration date of offers and counter offers, and that we should be addressing it in our counters, right? So, for example, I get an offer from a buyer today, and my seller is out of town until next Wednesday, right? So what is that, 5 days from now, right? 6 days from now. So there's the earliest that I could present their offer and write a counter would be the following Wednesday, but it's probably going to be Thursday. So by that time, the default of the purchase agreement is that it expires in 3 days, right? The expiration date of a purchase agreement is 3 days from the date it was created. So we've had conversations in the past when we've talked about counters where if I send you an offer and it expires and now I'm going to counter it because I have presented it, I like for you guys to reference in your counter that the buyer is acknowledging that that expired offer is still valid for us to move forward with the counter offer. So it's not something that you guys do on a regular basis. I'm sure that you probably have, most of you have never added that to a counter offer, but we consistently are countering offers that have expired. Happens all the time. It's not uncommon. So what CAR has done now is they have addressed it. The first one is offer. Seller makes this counteroffer on the terms above and acknowledges receipt of a copy. By making this counteroffer, any previous offer or counteroffer can no longer be accepted. This counteroffer is valid regardless of whether any previous offer or counteroffer expired by its terms. So what it's saying is like, hey, this counter is valid even if your purchase agreement has already expired. And down here, it has now a late acceptance. Like, hey, if the date of buyer's signature in paragraph 5 is after the expiration specified in paragraph 2A, buyer's acceptance is only binding if seller agrees to the late acceptance by signing below before 5 p.m. on the third day after the date the seller counteroffer is signed in paragraph 5. So if I send you a counteroffer, okay, and your offer has already expired, it's now saying, hey, this counter is valid to that that purchase agreement that was, even though it was expired, right? So I do what the scenario we talked about. My seller shows up on Wednesday. I present offers on Thursday. Your offer expired last Sunday. You're on Sunday, right? But this is saying if I send you a counter to that offer, you're acknowledging that this counter is valid regardless of that offer expired. And now on Thursday, I send you the counteroffer, and that counteroffer expires in 3 days. So that counteroffer will expire on the following Sunday. You don't send me the signed counteroffer until Tuesday of the following week saying we've accepted it. It's only accepted if I now sign it and send it back to you because it was late. Okay? And this is just a regular seller counteroffer. So for you buyer's agents that sit on counteroffers and don't send them on time, if you don't send this before it expires, now let's say you send it before it expires, right? You get it on Thursday, it expires Sunday, you send it Saturday, it's accepted. This doesn't matter. But if you wait till after Sunday, you send it Monday morning, if the seller does not sign this and send it back to you, your counter is not accepted. They can move on with somebody else. So again, I like that CAR has done this where they address directly, hey, we're dealing with expired offers, because as agents, we failed to do it. And I'm guessing in the conversations I've had with you guys about it is that there was an issue legally saying that that offer wasn't valid that you countered, so we're not moving forward. So they had to do something. All these changes come from some kind of a dispute. So either a dispute or they've talked to agents where they've had issues, like we're talking about with the changes, like getting rid of the SPBB and things like that. This came from a dispute. Somebody came up and said, hey, I don't think this contract is binding any further because it was expired at the time I signed your counteroffer. Probably a buyer that was going to be losing their deposit because of some time periods or something, and then said, well, this transaction is not valid anyway because my offer had expired prior to you countering it, so we want out. And so they found that legal loophole. CAR's closing it up. So I was patting myself on the back a little bit for when I read this, saying like, hey, this is something I told people to do, and now CAR's making everybody do it. Questions about this is also on the buyer's counteroffer, and it is on the SMCO as well. I think did I pull one up? I thought I did. Hold on. Let's look at the SMCO just to make sure. And let's see. Let's look at that. Here's the SMCO. So there's the verbiage. This counteroffer is valid regardless of whether any previous offer or counteroffer is expired by its terms. Here, by signing below, seller accepts the seller multiple counteroffer. Here's the late acceptance. This is now for the buyer talking about this paragraph 8, right? So if you get it back and the seller doesn't sign this until after it's expired, then the buyer has to sign this late acceptance in order for it. So you got some extra signatures in there for the SMCO. Okay. So I do like that they have addressed that we're going to try to close loopholes for expired listings. And like I said, the BCO, the buyer's counteroffer, has it on there also. Where is that? Just so you guys can see it. And here's the buyer's counteroffer also. That also has that verbiage with the late acceptance. If the seller signs it and returns it after it's expired, if the buyer wants to agree to it, they sign it here just like the seller did and like the buyer does on the SMCO. So I like that. I think that, again, all this stuff is just trying to make things clearer, more transparency, getting everybody on the same page so there is no question on whether or not something was valid or invalid. Questions about the counteroffers? Anybody? No? All right. Let's see. A couple. Which this one? I don't want to do that one yet. Let's do this first. This is a new form. This is the estimated compensation cost for the buyer. And so what you can do with this is kind of show the buyer based on 3 different scenarios what their costs are going to be as far as compensation goes, right? So you could say, here's scenario 1, seller pays buyer's broker in full. So you put the purchase price in, the buyer's broker total compensation, where it's coming from, buyer broker compensation paid by seller. This is showing a 0 paid by the buyer. So it's showing them exactly, this is purchase price 1, scenario 1. Scenario 2 is seller pays buyer's broker in part. So this is saying in this scenario 2 that the seller is only paying a portion of the buyer representation's compensation that you had listed on the BRBC. So you could put here to show exactly what their costs are going to be. Scenario 3 is the seller's not paying anything. So you could see. Okay. And then here we go based on a second purchase price. So you could show how that's going to work. Again, it's just a way to kind of visually show the buyer how the compensation is going to work. There is one for the seller as well. So you can say this form, this is the use. This form is a tool to explain the net proceeds a seller will receive after considering different methods for compensation of buyer's brokers. So purchase price number 1, scenario 1, seller pays buyer's broker a certain percent. Here's what it's going to be. Seller's proceeds. Scenario 2, seller pays buyer's broker this percent. And then you get the net proceeds. Scenario 3, seller does not pay. Then you get the net proceeds. So you can kind of show them just in general, just based on compensation, not about their other fees and costs and things like that. This is not a full-on net sheet. This is just about how the seller's proceeds are going to be affected by paying compensation or the concession for compensation to the buyer's broker. Then scenario 2 for another purchase price. So you could do this for 2 different purchase prices. So maybe you have 2 separate offers, different purchase prices. You can show them just visually, hey, this is what it's going to look like, the difference between these 3 options to pay. Okay. And this is the seller's contingency removal. Oh, before we do that, anybody have any questions about that? Let's see. Someone put Palm One app has a new compensation calculator as well with 3 options. Perfect. That's great. If there's a tool out there that can help you with it, use it. Just this is also, Sierra's, some people are, not super techie, so it's nice to have a piece of paper that they could show their clients. But yeah, whatever you have that's going to help you to verbalize to your client, whether it be buyer or seller, how the costs are affected by compensation being paid or not paid, I think is a great tool. So you have some other tools here as far as compensation goes. Yeah, Jesus, you had a question. Go ahead.
Okay, so we're saying scenario 1, 2, and 3.
Yes.
That is the percentage of the commission they buy right at the moment. That'll be where the seller will pay to the buying agent, correct?
Yes.
The selling agent.
Yes.
Oh, percentage, not the amount. And then in the bottom, what does it say? Seller payment to.
Okay, so look, let's say here. Okay, scenario one is seller pays 3%. So the purchase price is 600, right? The seller's going to pay us, the seller broker, 3%, right? So that's 18,000. They're going to pay the buyer's broker 18,000. So 600 minus 36,000 is going to go here. In this scenario, you're only going to pay the buyer's broker 2%. Here's the purchase price is 600,000. Seller's broker's getting 3%. There's 18,000. They're only getting 2. That's 12. So we're going to remove $30,000 from the net proceeds. So 600,000 minus 30,000 goes right here. Here is you're only paying me 600,000, 18,000, 0. Here's what your net proceeds look like. That's all that scenario 1, 2, and 3 is. And then you have a different purchase price. Hey, they went up to 620. So let's do the math. That's it.
And when do we present this document? What's the name of the document?
I think this is the estimated compensation cost for seller. I think you would do this when you got offers. If you wanted to prepare this for different offers, like, hey, for example, you're listed at 600 or you're listed at 620 and you get an offer at 600 asking for compensation. You do one at 600 and then you do one at your list price. See what it looks like. And then you say, okay, based on this, what are we going to counter? And the seller could say, well, I want to counter scenario 2. I want a 620 sales price with only 2% being paid, right? I want to be scenario 2 of purchase price 2. That's it. It's just a way for us to have a conversation. Somebody put, are these forms mandatory? No, they're not mandatory. They're simply a tool for you guys to use. These are not, this form specifically is not mandatory. The compensation cost estimated, that's not mandatory. Okay, so you don't have to use it, but I just think it's just a nice visual tool for how you could have a conversation about it. I think fidelity would be a
listing presentation.
Yeah, or listing presentation, or when you do it with your offer, right? You get offers in and say, okay, I prepared this for each offer, right? Because not every broker is going to ask you for 3%. Right, every buyer's broker is going to require 3%. So you could do scenario 1, 2, and 3 with 3 different offers, and it could be 2.5 and 2, 3 and 2, 2 and 1.5. Right, you could do all kinds of different combinations based on the conversations you've had with your seller. At the listing agreement, right? Or the listing presentation, the conversation with your seller is not about the specific amount they want to pay, but are they willing to contribute that concession for buyer representation? And showing them what it looks like that one, you're going to do net sheets, where you're going to say, look, I did a net sheet if you offer to pay 3, I did a net sheet if you offer to pay 2, and I did a net sheet if you offer to pay 0. Here are the 3 net sheets, just so you can see what it looks like if you're willing to pay compensation, and let them, make a decision based on that. That's different at the listing presentation. I think this is just more like, hey, based on this offer, this is what it looks like. And you could go far enough to go full on net sheet too. When you get offers, hey, I did a full-on net sheet based on this. I think it would get a little bit tedious if you were doing multiple scenario full-on net sheets. This is just like a little supplement to that. Okay. Any other questions? No? All right. Let's see. And the last one, well, let's see. This is cancellation of agency confirmation, amendment to purchase agreement. I don't think this is the one I wanted to talk to you about, but there is now, like, for example, if I had a purchase agreement with that we were already agreed to, and I wanted to cancel, I wanted to move to another agent, or I didn't want to work with that agent anymore. That's what that's for. I think we'll talk about that at another date. We're already at 11:51. I think that what we'll do is next week we'll look at a couple other of the new forms. I'm going to stop sharing here. Anybody else have any other questions? Let me see. What is this one? They have the wording slightly different. One has directly to. Does that matter? One is for a buyer estimated cost and one is for a seller. So I think that's probably why there's some different verbiage. All right. So anybody have any other questions? We'll let you go a little bit early. Like I said, think I'm looking forward to these changes that are happening. And remember, these forms are supposed to be released on December 16th. If you want to take a look at them, I think that if you go and open your zip forms, there should be a little pop-up that says that is a link to the red line forms, the ones that I just showed you. And it's there's a ton of them in there because there's things for tenants, and so there's a ton of forms. But next week we'll go over some more that I think you guys are going to be using most often, or that are important to you. Yes, Jasmine, go ahead. Did you have a question, Jasmine? Your hand was up.
Can you hear me?
Yes.
Okay. So you said all these changes are effective December 16th?
These forms should be released on the 16th.
Okay, so anything before the 16th, let's just say we get listings and all that before then we could go buy the forms that you previously trained us on, right? And after the 16th, any new listings?
Yes.
Okay.
Yes.
All right. Thank you.
Yes. All right, Tito, go ahead.
Yes. Regarding the compensations in our MLS, they don't allow it. How about other MLSs that you know that allow it?
Well, not for compensation, and I don't know about concession amounts. Like I said, ours will just let you put yes or no that the seller's, willing to entertain concessions. I don't know about other MLSs whether or not they do. I mean, CRMLS is the biggest one in California. I don't know if any of the smaller ones, like Victor Valley or any of those, if they're allowing you to put the amount of the concession, but none of them can say compensation to buyer's broker. Like, nothing can reference that at all. I just know on ours, on CRMLS, even if you put any kind of numbers in the private or public remarks, it gets flagged and they take it out. So just know that that's, a possibility. And later on, they're going to stop flagging it. They're just going to start fining you guys. So just be very careful. All right. Any other questions? No. All right. Well, I appreciate you guys being here. Again, like I said, I think these are good additions and changes. So if you guys have any questions, you know where to find me. If you missed any of this from the beginning, or you want to just go through it again, it will be on YouTube a little bit later today. Again, make sure everybody knows about that YouTube channel too, because just people that don't visit it, and the more that we can educate our fellow agents, the easier our job gets, obviously. Again, I thank you guys for being here, and I will see you again next Thursday. Take care.